The Honorable, the judges of the United States Court of Appeals for the Fourth Circuit.
Okay.
Oyez, oyez, oyez. All persons having any manner or form of business before the Honorable United States Court of Appeals for the Fourth Circuit are admonished to draw nigh and give their attention, for the court is now sitting. God save the United States and this honorable court.
Please be seated. All right, we're prepared to hear argument in our first case, Coleman v. Whitney. Ms. Potozak.
Good morning, Your Honor. May it please the court, my name is Paula Potozak. I represent Trinette Coleman in this appeal from the lower court's decision to dismiss.
You're welcome, but are not required to take your mask off.
Oh, actually, thank you for reminding me. To reverse the lower court's ruling, which granted summary judgment to the United States Army on the issues of disparate treatment, racial discrimination, gender discrimination, essentially, and hostile work environment. And we ask this because there are material issues of fact in essentially three crucial areas. One is job performance, two is the issue of comparators, and the third one is the actual discriminatory treatment that Ms. Coleman experienced throughout her tenure at the Korean facility, the Korean military facility. As to job performance, the lower court essentially made a finding of fact, which was not within the judge's province to do in summary judgment. And the error is this: the Army admitted that there was failure to train on GIBIS, which is evidently a very complicated computer system that Ms. Coleman was absolutely necessary for Ms. Coleman to have in her performance. They acknowledged in answers to interrogatories that they failed to train, and they all, Ms. Hornsby, who was head of HR for the Army, admitted and acknowledged in two places, her deposition and in emails, to Ms. Coleman's second line supervisor, that the Army HR had essentially failed Ms. Coleman in how they trained her on the GFEBS system, which she could not use at all until August of 2012. She entered into service in February. So essentially for 6 months of her 8 months evaluation period, she had no access to the system, or very limited access. That is essentially.
If she had had access, would she have had the experience to be able to do her job?
Yes, she had her experience to do other functions of her job, such as the DTS, which is the tracking service for budgetary travel and things like that within the Army. She had that experience from her previous position. She had, as within any new job for any new employee, questions about certain functions as to how this particular office did the work, but she did have those capabilities. She was hired because of those capabilities. And in fact, during her panel interviews, it was represented to her that she did not need to know the GFEBS system and that she would learn it on the job. She took her online training system, the online training courses. She completed them in May. The Army then added additional requirements, two or three of which had to be in person.
I'm sorry, you said earlier you blamed the Army. You said from February to August. But then you just said she didn't complete her training until, or at least the first part of her training, until May. Right, so isn't she then responsible for having not completed the training?
There were 20 courses that she had to take, Your Honor, over a period of time. There was no time limitation on her.
No, I'm not blaming her
No.
for taking a long time. I mean,
No,
maybe, but the point is, the Army's not responsible. Like, the Army says, you must do that. If I hand you a piece of paper and say, you must fill out this piece of paper before you do X, and you take 6 months to fill out the paper, that may be perfectly fine. I didn't put a time limit on it when I gave it to you, but you can't do X until you fill out the piece of paper.
Ms. Coleman was not given any time frame within which to complete.
Totally fair, but I hand you the piece of paper and I say, you cannot go to such and such a place until you fill out this piece of paper. I didn't say, and you must fill out the piece of paper before a certain date, but you can't go until you fill out the paper. So it's in the hypothetical I'm giving you, the delay in you going to this place or doing X is you not filling out the piece of paper.
But she did the courses as soon as she was able to do the courses. There was no time limit
That's
on
the
them.
question. The question that we're challenging or having trouble with is whether her abilities allowed her to do the job. I think that was Judge Thacker's question. Yes, she might have done it as quick as she can, right? But the question is whether that ability, like if it took her that long to do it, maybe that's really not the Army's fault for not giving her access, but her inability to comprehend and manage the job.
So I think I misunderstood the question. So the question is essentially whether or not she had, for want of a better way to characterize it, the intellectual ability to study and learn the GFEBS system. And to that, the answer is yes, because she successfully completed the courses as they sort of rolled off the online training.
Totally fair, but if my daughter completes algebra, but it takes her 4 years to do the 1-year class, we might think that she's not a math whiz,
But
right?
No offense to your daughter, but
Right.
yes. But that is not the situation, and there's no factual support for that.
And I know, but we began with the idea that you said, oh, the Army didn't give her access. It was the Army's fault from February to August. They wouldn't give her access. But then you turn right around and say, but she couldn't complete the required, precursors until sometime in May. And that wasn't even all of the precursors, right?
Well, it wasn't all the precursors because the Army then added additional precursors for her.
What that might have been important because it took her like 4 times as long to finish,
No,
right?
No, the additional courses were part of the, for want of a better word, standard training for Army employees to be able to function within GFEBS. In addition, there is nothing in the record that intimates at all that she was incapable of learning the material. It was that she did what she was asked to do, did it from what you can divine from the record in a timely and appropriate fashion, submitted the certificates, and had additional courses added.
Counsel, excuse me. What does all this have to do with race? I mean, there are situations where people experience disappointments in the job and they don't get promoted as quickly as they wanted, or they didn't get this, or they didn't get that. But the explanation for disappointment is not always racial. And I don't understand. You have a disagreement with the Army over access and over the quality of performance, but what does it have to do with race?
It has to do with race, Your Honor, Judge Wilkinson, because the office into which she started in February of 2012 had a serious problem with racial animus. At the point in time she started, her hiring supervisor was accused of being a racist and being anti-Korean, and there was a vitriolic complaint lodged against him.
She's not Korean, right?
No, but Mr. Bridges, the gentleman against whom the complaint was lodged, is African American Black. He hired her. There was a second anonymous complaint submitted to the Army system, which directly implicated Ms. Coleman, called her incapable, stated that she was hired only because she was Black, that Mr. Bridges hired only Blacks. And I believe it was also in that anonymous complaint where it was pretty much stated that he hired her because she was a Black female, the underlying intimation being that there was an illicit relationship of some sort going on.
But what makes the delay in the promotion? The Army has cited the fact that reports were handed in late, and that there were all sorts of they were riddled through with errors that required a more intensive editing, and she eventually got the training she wanted. She got the promotion she wanted, but what showing is there that these deficiencies that were noted in her performance, how is that pretextual? And in any way, it seemed to me that they had a pretty good basis for finding that the performance was subpar, and that's their view. They seem to act on it. But how is that pretext for racial discrimination?
It is pretextual, Your Honor, because, well, two things. Number one, Ms. Cha, who was tasked to train her both in GFEBS and in just regular office procedures, made it very clear early on that she didn't like and not that she didn't like Miss Coleman, but she resented Miss Coleman. She told her superiors as well as Miss Coleman that she should have gotten the job. That is, Miss Cha should have gotten the job, and that Miss Coleman got the job only because she was Black and Mr. Bridgers hired Blacks. That's sort of one. Two, Miss Cha repeatedly made racial comments to Miss Coleman about her accent and how she had a funny accent and she couldn't understand her.
How are Ms. Chaw's comments and actions and statements imputable to Ms. Coleman's employer, the Army?
Ms. Cha advised Mr. Skillen at a minimum, and there are emails and depositions testimony to this effect, that Ms. Cha was hired only because she was Black, that she hated Koreans, that.
But how does her advising Mr. Skillen make what she did imputable to the Army?
Well, Mr. Skillen is the supervisor. He knew about the racial.
Who's
animus.
Ms. Hornsby? Is she above Mr. Skillen?
Not in a direct organizational sense, but she is head of HR and work.
She's head of HR. Did Ms. Hornsby agree with Mr. Skillen and Mr. Dickman that Ms. Coleman's performance was not where it needed to be and she was struggling?
Ms. Hornsby testified, and there's also an email to this effect, that the Army failed Ms. Coleman in training her.
That what my question is, didn't Ms. Hornsby say, I agree with you completely, that at her level, she should know the basics of budgeting, and that her performance was not where it needed to be? That's in an August 17th, 2012 email at JA 638. Ms. Hornsby said that, correct?
Yes.
All right. And is Ms. Hornsby Black?
Yes, I believe so. I am actually not.
I think it's in the record.
I don't think I did focus on that, but I believe that she is. Yeah.
Okay, so going back to Judge Wilkinson's question, how is the delay in her promotion based on race when it's not? I don't see how it's imputable to the employer, and one of the supervisors, who the head of HR, also found that her performance was not where it needed to be. Now, they did give her training and her performance got to where it needed to be and she was promoted. But how is this all based on race?
The way in which she was not trained, if you will, within her office.
Can you please speak up? I'm having difficulty hearing you, and I want to make sure that I do.
I'm sorry, Your Honor. The way in which she was trained or not trained, the atmosphere in the office in which she worked was so imbued with racial animus that it affected everything along the way. Ms. Cha would not answer her questions. There were issues.
Was Ms. Cho her supervisor
She
or
was,
her coworker?
she was a coworker instructed by the supervisors, Mr. Skillen and Mr. Dickman, well, Mr. Bridges, Mr. Dickman later on, to teach Ms. Coleman office procedures and to help her get to know GFEBS. They were coworkers in the sense that they were both GS 11s. But it's imputable to the Army, the supervisors, because the supervisors knew this was going on and did nothing about it. Ms. Hornsby is not a supervisor in the sense of a rating supervisor or giving Ms. Coleman reviews. Mr. Dickman and Mr. Skillen did not understand or know budgeting or how to, and had never supervised budget analysts, and they were inquiring to Ms. Hornsby for advice as to how to handle this. She was.
All right, thank you. Thank you, counsel. And if you've got some time for rebuttal, and we will hear from you at that point, okay?
Thank you, Your Honor.
Ms. Marquardt, we'd be pleased to hear your side of it.
Thank you, Your Honor. May it please the court, Sarah Marquardt on behalf of the Secretary of the U.S. Department of Army. Your Honors, this entire lawsuit boils down to Ms. Coleman's disagreement about the timing of her promotion. Ms. Coleman was only eligible for a promotion after 1 year, provided she performed satisfactorily during her first year at the GS 11 level. There was no automatic promotion. Ms. Coleman sets forth an unsubstantiated narrative that the workplace was marred with hatred towards her. This is not grounded in fact.
Wait a minute. Ms. Cha did make a number of discriminatory and derogatory statements about Ms. Coleman, didn't she?
Ms. Cha and Ms. Coleman certainly had a disharmonious relationship, Your Honor. I will certainly agree with that. And Ms. Cha did make statements to Ms. Coleman that were rude and insulting, quite frankly. But how that is imputable to her employer is an entirely separate issue.
Right. I was just remarking on your statement that the allegations of discriminatory animus within the office place are not based in fact.
And
that was you were trying to say with regard to the promotion, right?
Exactly.
Not
Your
that
Honor.
none of this happened.
Certainly, I will not dispute that there were some racial overtones within the workplace, certainly. However, how that is imputable to her employers is an entirely separate issue and why we are here today. Her employers, there's no genuine dispute of fact that her employers, Mr. Skillen, Mr. Dickman, Ms. Hornsby, Ms. Panther, harbored any discriminatory animus towards her. And as required at the summary judgment level, the district court construed the facts of the record as opposed to Ms. Coleman's speculations that her supervisors embraced these statements by Ms. Cha, her colleague, not a supervisor. And the district court construed these facts in the light most favorable to Ms. Coleman and correctly found that there is no dispute of fact. And Ms. Coleman has offered no persuasive grounds for the reversal of that sound decision. The record is quite clear, Your Honors, that as a GS employee, Ms. Coleman was hired with the presumption that she had the skills necessary to perform at the GS level. When she came on board, it became quite apparent very quickly that she did not have those skills. The record reveals that Ms. Coleman herself testified that she was constantly criticized by her supervisors for
So
routine.
then why did it take so long to provide her with the training she needed and to give her access to the system that she needed?
Your Honor, it did not take as long as Ms. Coleman would like this court to suggest.
How long did it take?
There was a mere 4-week delay after she completed the required courses. So Ms. Coleman's suggestion.
So a month after it took a month after she completed the required courses for her gain access to the information she needed on the computer to do her job?
No, Your Honor, that is not correct. I am referring specifically to the GFIBS system, which is the Army's budgeting system.
Well, isn't
And-
that what she was hired to work on, budgeting?
It was access to the GFIB system was certainly a portion of her job, Your Honor, but it was not the end all be all. And this is quite apparent on Joint Appendix 132 to 138. And this sets forth all of Ms. Coleman's job duties. Some of those job duties had to do with GFIBs, but certainly not all. And Ms. Coleman testified.
So in that month delay between her finishing the training and the Army giving her access to GFIBs, she didn't have any work that would have required her to be on GFIBs?
Your Honor, I'm not sure if I can unequivocally say that there was no work that might have needed GFIBS access, but certainly she was a very busy employee with a host of other job duties. And what's important here, Your Honor, is that
I'm sorry, what were the J sites you mentioned a minute ago? 132?
132 to 138, Ms. Coleman
Okay, thanks.
testifies with regard to her other job duties. For example, providing advice and assistance in the development of budget requests, planning and estimating funding needs for civilian pay entitlements, benefits, travels, and contracts, managing the overall system for the defense travel system, review and adjusting regional tables of distribution.
Anyway, going
allowances.
back to my question before, I think it was, why did it take so long? Why did it take a month for the Army to give her access to the GFIBS system?
And Your Honor, there were some security concerns. There's mention of this on JA 189 to 190. There were computer permissions that Ms. Coleman had to obtain in order to grant that access. And if Your Honors will recall, this is an unusual employment environment and that Ms. Coleman was situated in Korea and is dealing with security issues across the entire world in Aberdeen, Maryland. So certainly there was a delay, but how that.
So can you point me to where in the record we can best understand the source of that delay? So in other words, you might imagine that delay coming from the United States, right? This side of the pond, if you would, and you might imagine it coming from the Korean side of the pond, not to overgeneralize too grossly. Is there anywhere in the record we could look to see that for that 4 weeks, is it responsible in the United States, is responsible there? And the reason I ask is obviously if it's in Maryland, it strikes me as less likely to be related to whatever degree of animus existed in Korea.
Certainly. Your Honor, JA 189 to 190 references the security issues that were at play in accessing the system. To answer Your Honor's direct question, I don't believe that the record explicitly says whether those computer permissions and the security issues were housed in Korea or in Aberdeen, Maryland, but I feel comfortable representing to the courts that because the HR
It's
system.
not in the record. It doesn't help me.
Right.
You're representing, I don't,
No,
it's not a knock on you.
Certainly.
And I guess, let me ask it slightly differently. Is there any indication that Ms. Cha was responsible for computer access or security issues within the organization?
No indication of that in the record at all, Your Honor. The record does not support that.
When I was reading the record as a whole, it seemed to me that there were a great range or a significant range of deficiencies in her job performance, and that those deficiencies were independent of GFEB, any training or lack thereof, that the reports were simply riddled with errors, and that they were late, and that had led to the delay. And I didn't understand that I didn't see where many of those deficiencies, which were independent of GFEBs, were in dispute. Am I correct in that?
You're absolutely correct in that, Your Honor, and I'm happy to point the court to some examples that Your Honor references with regard to those issues that, quite frankly, Ms. Coleman lacked the basic budgetary understandings that the job required. Her work on the PBAC forms was incorrect. Joint Appendix 203, 206 to 207, and 210. She was not grasping the complexities of budget work that a GS11 employee should have, 374. She required reminders regarding basic budgeting principles, such as the differences between reimbursable and direct funded employees, JA 336. Monthly reports had to be reworked because of this mistake. Mr. Dickman had issues with Ms. Coleman's basic understanding of the budget. JA 1137. She didn't grasp the complexities of her position. JA 1042. Not only did she lack the basic budgeting principles, as your honor notes, that are separate and apart from any access to GFIBs, her work was untimely. So not only was it flawed, it was untimely as well. Your honors can find references to this at Joint Appendix 742, 1042 through 44, where Mr. Skillen and Mr. Dickman testified that Ms. Coleman frequently missed deadlines for submissions to reports to headquarters, and that because of her untimely work, because of this deficient work that had nothing at all to do with access to GFIBs, they required her to submit reports in advance of headquarters deadlines, or to give them updates to ensure that she remained on schedule. So Ms. Coleman blaming her access to GFIBs does not represent the entire picture. And what the factual record shows, your honors, is that she exhibited performance deficiencies from the start. She had to complete courses for her GFIBs access. She took some time, as Judge Richardson noted, in completing that access, and then ultimately got access to the system. If your honors may, I'd like to turn briefly to Ms. Coleman's argument that similarly situated employees outside of her protected class were treated differently. The district court soundly determined that Ms. Coleman has not shown that similarly situated employees outside her protected class were treated differently with respect to the adverse employment action that she alleges. And I want to circle back and harp on the fact that the only adverse employment action at issue here is a 4-month delay in promotion. The agency didn't terminate her. The agency didn't let her out to continue with these performance deficiencies. What the record shows is that Mr. Skillen, upon giving her the fair or needs improvement performance rating, counseled her for over an hour on her performance and how to improve her performance. And also worth noting is the fact that the agency sent her on an overseas trip to Aberdeen, Maryland. This is the first time ever the agency has engaged in this type of expense for an employee to observe in-person training. As your honors can imagine, this is not an inexpensive trip. It was a $5,000 cost to the agency to send Ms. Coleman. And it did this because it was trying to better her performance. It was trying to help her. And she did improve. She did turn around and show improvement. And when she showed improvement.
Was the Maryland trip in the timeline after the low performance review and before the what I call the promotion? Or was it before I'm just trying to understand where in the timeline we think that occurred.
Certainly, your honor. She was on the job for several months. Ms. Hornsby recommended that she travel to the headquarters in June. I believe that the training was in the fall, and then her appraisal was for the February 13th through the October 31st rating.
Around the same time, we don't know, at least as you're looking at it, we don't know if it happened before. She was recommended well before in June, but whether she went before or after she got the unsatisfactory rating, we don't know.
It was certainly after she received that in-person training and counsel during her review that her performance began to turn around. And that was in the fall, late fall of that time period.
Did you finish everything you wanted to say about the similarly situated?
No, Your Honor,
issue?
if I may, I'd like to circle back to that. The comparator that Ms. Coleman points to, Ms. Chaw, first of all, with regard to gender, it's inherently fatal to her gender discrimination claim because Ms. Chaw is also a female and not outside Ms. Coleman's protected class. Turning to the race and color allegations, Ms. Chaw, the district court soundly determined that Ms. Chaw is an insufficient comparator. There are distinct differences between their job duties, the GS classifications, and their employment histories. Let's turn to job title. They had different job title, management analyst versus budget analyst. They had different job duties, JA 200, JA 876, highlights some of these differences. And perhaps most significantly, Your Honors, Ms. Chaw's job was not a developmental position like Ms. Coleman. So she did not have the opportunity to automatically advance to a GS-12, assuming she had good performance. Ms. Chaw was a strict GS-11 employee and simply did not have the same opportunities. She was never given a position, an advancement to a permanent promotion to GS-12.
Is that, I'm sorry, the GS scale remains a black box to me, but here she started, Ms. Coleman started at 11, and what she was trying to get and what ultimately got 4 months late was a promotion to GS-12.
That's exactly correct, Your Honor.
And Ms. Chaw, what you're saying is Ms. Chaw was an 11 and was never considered for a 12.
That's correct, Your Honor.
And so to use her as a comparator for a delay in getting to 12 doesn't get you very far.
That's correct. She was maxed out at GS-11.
Which is why Ms. Chaw had applied for Ms. Coleman's job, because she wanted the ability to.
She wanted the ability to advance. And I think that point highlights a lot of the disharmonious relationship at play here in this workplace. Ms. Chaw wanted that job. She trained herself using binders and job aids. And when Ms. Coleman came on board to a job that she wanted, she expected her colleague to be able to get up to speed. And she was not able to get up to speed. And for all of the reasons that I highlighted previously, access to GFIBs is inconsequential to that. She had a host of other job duties, and she did not demonstrate the basic budgetary principles that were required.
Is there anything further, Counsel? Is there anything further?
I'm sorry, Your Honor.
Do you have anything further?
Your Honor, the one issue that I have not touched on, if I may, is the hostile work environment claim. And Ms. Coleman has not shown, and the district court appropriately determined, that there was no conduct that occurred because of her race, color, or gender, nor was it sufficiently severe or pervasive to create an objectively hostile, abusive work environment. This, as Your Honors know, the sufficiently severe or pervasive standard is a very high standard. Rude treatment by a coworker will never meet that standard. The only conduct that Ms. Coleman spoke to with regard to her supervisors was that Mr. Skillen constantly criticized her work. He told her, "I would never hire you. You don't know what you're doing." That's rude. It's not something that an employee wants to hear. It's certainly not sufficiently severe or pervasive. And for all of the reasons that I've argued before this honorable court, Mr. Skillen was arguably frustrated with Ms. Coleman's performance. She didn't know how to do the basic principles of her job. So he was arguably in his right to express some frustrations over her inability to carry out the rudimentary principles. With regard to any claims of Ms. Chaw, Ms. Coleman also has the burden of showing that that is imputable to her employer. Harassment by a coworker resulting in a hostile work environment can be imputable to an employer, but only if the
Can you talk for
employer.
just a second about, I mean, the one part of this that just the district court's analysis that I was curious about, is Cha's alleged statement to Coleman that she was hired only because she was Black. And there's also sort of some record about Mr. Bridgers and him being disciplined in the manner of his hiring or treating of employees. Can you talk about those? Is there anything that I need to know about Mr. Bridgers to evaluate Ms. Cha's statement?
There's nothing that you need to know, Your Honor. There's a big background with Mr. Bridges and that he was investigated for being just disrespectful to Korean nationals. He took around Korean employees to do his dry cleaning and to translate and do all these improper things. So he was investigated for some inappropriate activities within the workplace, which eventually resulted in his leaving the workplace. That is a complete side issue. Ms. Coleman is wrong to try to import the claims of bias against Bridges and bootstrap them to her claims.
No, I guess I was thinking about it a little bit differently, right? That if Mr. Bridgers was found to be discriminatory to Koreans, and if you take that to the extreme, then the statement that she was hired because she was Black might, or at least because she was non-Korean, might well have been true. We're just trying to figure out whether that matters.
It does not matter, Your Honor, respectfully, because we're looking here at what her supervisors on the ground, i.e. Mr. Skillen and Mr. Dickman, observed regarding her performance.
Not about hiring.
Exactly. It's inconsequential.
Thank you.
With that, I see my time is up. Thank you very much.
All right, thank you very much. And Ms. Potozak, you've reserved some time for rebuttal, and we'll be pleased to hear from you in rebuttal.
As to the comparator decision by the lower court, the issue of whether or not a comparator is appropriate is a question for the jury, and it's not one that the lower court should have made. That's number one. Number two,
You think that's true with respect to her gender? That you got to submit to the jury whether Ms. Cha, shouldn't say Ms. Cha, the person identified as Cha is a woman?
Ms. Cha is a woman, and the gender issue is not. We are not advancing a straight gender discrimination. It is just.
Okay. What about the fact that Ms. Cha was a GS-11 and not eligible for promotion to a GS-12?
I think in this case, Your Honor, it is not determinative and is not quite.
Well, but does it need to be submitted to a jury is what I'm asking. You said all of this needs to go to a jury,
Well,
whether she's a proper comparator. And so I was asking about some of the comparisons.
I think that to the extent that it is a question of fact as to whether or not the comparator to be similarly situated both had to be a GS-11/12.
But you agree
then yes.
she's an 11, Ms. Cha was an 11, not eligible for the automatic promotion that your client wanted.
Correct, but I don't think that's determinative. It is certainly an issue of fact as to whether or not it is determinative to be sent to the jury, but there are so many other similarities between what Cha and Coleman did, virtually identical, that the fact that Cha could not get a 12, it was not a GS-11/12, which is an automatic promotion, it's something to consider, but it's not the most determinative item in the panoply of facts that show how Cha and Coleman were comparators. They essentially did the same job. Coleman
and neither of them got a promotion to a 12 at the end of 1 year.
Ms. Cha got a promotion to a 12 at some point in time.
After your client.
I'm not sure about that. Ms. Coleman's promotion was effective May 31, 2013, and Ms. Cha got it before that. Ms. Cha got it at some point prior to May of 2013. And so the issue of comparators for the GS-12 issue is just one of many factors, and they don't have to be exact. Ms. Cha actually got GFEBS training. She went to Korea in the year prior when GFEBS was installed by the US Army. So that Ms. Cha got all of the training, if not more, than Ms. Coleman received. She got in-person training while she was in Korea, and then Ms. Cha went with various other persons from the headquarters in Seoul to Aberdeen Proving Ground to be trained on GFEBS, and that occurred prior to Ms. Coleman's hiring, because the GFEBS system was installed in essentially the end of 2012. So that Ms. Cha had tremendously more training and experience in doing the budget than Ms. Coleman had. And Ms. Cha, quite frankly, did the GFEBS budget tasks for a period of time when Ms. Coleman was not there. She knew the system very well, and that's why she was instructed to train her. The fact that she wanted the job and went to Mr. Skillen and said that the only reason this woman was hired is because she is Black colored the entire rest of their relationship, and is clearly what a huge fact in the disparate treatment that Ms. Coleman received in the office.
But don't you agree that after Ms. Coleman received the fair evaluation, or that she was not performing as she should, that she was counseled, they worked with her, they gave her training to get her to where she needed to be to get the promotion that she wanted, and she ultimately did get the promotion. So
there's no question that that happened, but it happened late, and it happened with a panoply of facts of racial discrimination and, quite frankly, racial.
what you mean 4 months, the 4-month delay, when you say it happened late?
The 4-month delay in the promotion is because of the way Ms. Coleman was treated and not trained properly from February until.
Treated by Ms. Cha.
And Mr. Skillen as well. I mean, Mr. Skillen knew that there was a racial issue between Coleman and Cha. He did nothing about it. He shrugged it off. The notion that an employee tells a supervisor that the only reason she was trained is because she is Black, and then just says she's venting, I think is indicative of the atmosphere in which Ms. Coleman was forced to work.
All right, thank you very much. We appreciate it. And we'll now move directly into our next case.
Third-year law student Jessica Matsuda and Brian Warren at Washington Lee University School of Law, who will be arguing the case under my supervision.
Good morning, Your Honors. May it please the court. Jessica Matsuda on behalf of the appellant in this case, Mr. Darwin Lee Payne. Your Honors, this court should fulfill the remedial purpose of the First Step Act by reversing the lower court and freeing Mr. Payne from his unjust felony sentence. 5 years of Mr. Payne's life were taken for simple possession of crack cocaine. And even now, after he has served those years, the brand of felon continues to punish him preventing him from federal employment.
Well, the key phrase there is after he has served those years. And how can a district court reduce a sentence that's already been served? And that's all the act permits is reduction of sentence, correct?
No, Your Honor, it doesn't. And the language in the act that points us to this conclusion is in section 404B itself. And that language gives the court the ability to impose a reduced sentence onto Mr. Payne under the Fair Sentencing Act.
And what language is that?
That language in 404B, Your Honor, which is the court may impose a reduced sentence onto Mr. Payne under the Fair Sentencing Act.
But how can the court impose a reduced sentence on a sentence that has already been served?
Well, Your Honor, there is still a part of Mr. Payne's original sentence that continuously penalizes him. That's that felony status that was eliminated by the Fair Sentencing Act. And the word impose here is
Status, though. That's not a sentence.
it's inextricably tied to his sentence, Your Honor.
No, Judge Thacker's point is, I think, the crucial one. A sentence is something pronounced by a court. And the court pronounced the sentence here. And the sentence that is pronounced by the court, the key word is sentence. The sentence that is pronounced by the court has been served. Now they're going to be, you know, in every situation, a sentence that has once been imposed is going to have some long-term consequences, because employers or whatever may look back at someone's record. So the consequences are often a long range, but the key sentence in the statute is the sentence. And a sentence is imposed by the court. And once the sentence has been served, there's nothing to reduce.
Well, Your Honor, for Mr. Payne, there is something still to be reduced in this case, because there is still a penalty attached to his sentence that is inextricably tied to the statute of conviction he was imposed under. Now,
No, but whatever was imposed by the court has been served, and that's the statutory language. It doesn't, the statute does not talk about inextricably tied or whatever. You're simply adding a gloss. And the question is, it's not only the question of sentence. You've got to look at the word reduce. And how do you reduce something that's already at zero?
well, Your Honor, the penalty still can be reduced, because for a simple possession offender, that penalty was changed to misdemeanor status, which is what Mr. Payne seeks in this case. But to speak further on the word impose, Your Honor, this circuit read that word broadly in Collington versus United States. Now, in that case, the word impose was meant to give a broader, greater authority to the lower court, not just as a reduction or a modification, but a new sentence under the Fair Sentencing Act in order to get rid of the unjust and unfair penalties under the old scheme. That's exactly what will happen.
Is there any case in which a court has reclassified a felony conviction to a misdemeanor conviction on any basis, whether it's the First Step Act or otherwise?
No, Your Honor, it would be this case, which is appropriate because the First Step Act gives Mr. Payne this mechanism, not just to reduce time as another statute would, say section 3582C2 specifically uses the words reduce a term of imprisonment. Those words are not used in the First Step Act. That's what this court pointed out in Collington, giving the lower court a greater remedy, a more broad remedy to correct a broad injustice, which was this unfair punishment under the older scheme, something that the Fair Sentencing Act corrected by reducing the statutory maximum from 20 years to 1 year. And it is a simple resentencing under the First Step Act that gets Mr. Payne to that status.
Can you help me a little bit with maybe what is sort of a subsidiary idea, but one that strikes me as maybe relevant? Most of the complaints that you have about his felony status stem from Virginia law, right? That's the Virginia limitations, not exclusively, but lots of them, or stem from federal law. Those seem to be the two, but the focus seems to be on Virginia law. Can you talk to me a little bit about how Virginia determines whether a out of jurisdiction conviction counts as a felony? Just in a run-of-the-mill case, right? If Virginia gets a South Carolina conviction and they're trying to determine whether this felony prohibition applies, what are the rules, or what is the manner in which you believe Virginia undertakes to determine whether a out of jurisdiction conviction counts as a felony or instead counts as a misdemeanor?
Well, I believe, Your Honor, it's the same as the federal status, which would be a sentence being convicted under a statute where the statutory maximum is over 1 year, which is statutory maximum of under 1 year would be a misdemeanor.
So I guess I mean, maybe, but I'm not, that seems odd to me. And at least the case law I found doesn't seem to suggest that they look to the federal system. So if they're looking for a South Carolina conviction, for example, South Carolina has a number of convictions that are 10-year misdemeanors. So in other words, you can get punished for 10 years, and yet it is classified under South Carolina law as a misdemeanor. And it seemed to me that Virginia would treat that by reference to the South Carolina jurisdiction, the manner in which South Carolina treats that. And so I guess I'm just curious, because then the question is that also true in the federal context? And then if we're looking at how federal law characterizes it, does that really help you here?
Well, it does, Your Honor, because federal law characterizes it in the way I've described, where if he is sentenced under the new statutory maximum, he is a misdemeanor because it's under a year, and that would directly affect his federal collateral consequences.
Except federal law says it's the available sentence at the time of sentencing, right? Sort of what the federal system
Yes.
says, right? And so at the time of the conviction here, he was eligible for 5 years. And so even if, I guess what I'm getting at is, even if you assume away Judge Thacker's good concerns, we still are left in a situation where at the time of his conviction, he was eligible to receive more than a year. And so I don't think it helps you, even if you get past Judge Thacker's concern. And that's what I'm trying to tease out a little bit.
Well, Your Honor, when he is resentenced under the First Step Act, it is a new sentence. So at that point, he does become a misdemeanor because the new statutory maximum is 1 year. And to the point that Judge Thacker made, if that is made available to him as the First Step Act intended retroactively, it does retroactively.
You know what the question is that when you look at the statute, you're supposed to only disturb the finality of the sentence. If of any sentence, if Congress has expressly authorized it. And those words expressly authorized are important because there is nothing that is expressly authorized here. You might say it's ambiguous or whatever, but it hasn't been expressly authorized to reduce a sentence that has been served. And if it was expressly authorized, it would seem that some court somewhere would have adopted the argument that you've made. But as I understand it, we all consider this to be an issue of first impression. Is that right?
Yes, Your Honor. And two answers.
All right. Well, what I'm saying is if it's an issue of first impression, whenever I hear those words, I'm thinking it's an issue of first impression because every litigant has had the prudence not to raise the issue, and no court has had the temerity to adopt it. But the modification of a final sentence has to be something that's expressly authorized by statute and by Congress. And however you read this, you seem to read it one way. I don't necessarily think that's right at all, but it falls far short of an express authorization to modify a sentence that has been served and that is no longer capable of reduction because it's already at zero. The sentence pronounced by the court is that it's been served, it's at zero. and you can't reduce zero. And the word reduction there, it's not only the word sentence that's crucial, it's the word reduce. And all that language goes against you.
Yes, Your Honor, I will say that the word reduced does modify the word impose, which there is a reduced sentence available to Mr. Payne. And to your point about the express authorization, Your Honor, it is our position that the natural language of the statute is broad enough in this circuit to encompass this relief. But even to that point, Your Honor, this argument that the government raises about express authorization limiting the statute, which is really from language in section 3582C1B.
Well, but that carries, the argument carries across the board. But I think that there's another, in addition to the textual problems that confront you, I think there's a separation of powers argument. And that is that we are talking about a classification, and that is something that is authorized by the legislature. And a sentence is something that is imposed by the court. These are two very different forms of authority. The legislative authorization, which classifies something as a misdemeanor or a felony, and then there is the sentence imposed by the court. And if we start redoing legislative classifications, it seems to me we are encroaching on the authority of a coordinate branch of government.
Well, you wouldn't be, Your Honor, because the legislator changed the statutory maximum itself in the Fair Sentencing Act and then made that change retroactive so the courts could impose new sentences under the First Step Act. To your point, Your Honor,
Can I ask you about that? Is that, do you read, so I don't read it as doing that. And that's why I'm a little, this is maybe a different version of the confusion, because it doesn't actually make it retroactive, right? What it says is that you should impose a reduced sentence as if new statutory maximum applied, not that the statutory maximum did itself apply, right? This as if, right, is sort of a, you should pretend as if it was retroactive, not it actually is retroactive. And so, at least from a congressional standpoint, that means that it hasn't made the statutory maximum retroactive. It's just told judges to treat it, to pretend like it is.
Well, Your Honor, it makes it available to someone like Mr. Payne to get the fair resentencing under the retroactive statute, as long as he meets the eligibility requirements, Your Honor.
It lets him get, that's right. It lets him get, it lets the judge pretend like the maximum is one, but it's not really one, right? We're just pretending that it is, right? So even if you get, we're sort of going through a number of different, hoops that are problems for you. But even if you get there, it seems a little hard to say that his statutory maximum today, right? If we look at that question sort of abstractly, even after the First Step Act, his statutory maximum is still 5 years. A court is instructed to pretend like it's 1 year.
Yes, Your Honor.
Right? But that's just pretending, right? And so if we're asking the question of whether the statutory maximum is 1 or 5, the answer to that question is 5.
No, Your Honor, it is the resentencing under the Fair Sentencing Act that actually gives any retroactivity, which this court has read the First Step Act statute to do to someone like Mr. Payne. It's not simply pretending, it's fully resentencing under the statute.
No, but the problem is there's a very limited grant in the First Step Act. Retroactivity is granted under a very limited set of conditions for a very limited number of offenses, which are tied to the Fair Sentencing Act of 2010. And the difficulty here is that you want a sweeping view of retroactivity, which would have courts look at long stale convictions in an effort to reclassify them in some sort of way. And you're asking us to step into an area and to reposition government resources and law enforcement resources more and more into retroactivity and to the long stale sentences that have already been served. And that again encroaches on legislative authority, which has provided no such retroactivity And if we follow you, we're going to be modifying a already imposed and served sentence, and we're going to reposition and reallocate prosecutorial and law enforcement resources without any legislative authorization. And that just seems to me, there's no wonder this is an issue of first impression, because nobody thought it was even a viable issue.
Your Honor, I see that my time is up. May I
You have some rebuttal time.
answer that question? For these honors, we'd ask the court to reverse. Thank you.
Good morning, and may it please the court. Jacqueline Bashara for the United States. As your honors have observed, there is no court that has used the First Step Act or the Declaratory Judgment Act to change the classification of a valid pre-Fair Sentencing Act offense involving crack cocaine. The district court correctly concluded that it could not do so here. To begin, Section 404 is a sentence reduction statute in which Congress authorized a narrow form of relief, specifically that a court that imposed a sentence for a covered offense may impose a reduced sentence.
But it's inconceivable, looking at that language with its emphasis on reduction and sentencing, that Congress somehow meant by that language to reduce sentences that have already been served. You simply cannot draw that conclusion from this language.
That's correct, Your Honor. The statute does not expressly permit that type of relief as required under 3582C1B to escape the presumption of
Aren't the
finality.
negative consequences that Mr. Payne is suffering now precisely the sorts of things Congress intended to address with the First Step Act and the Fair Sentencing Act?
Your Honor, members of Congress certainly recognize that individuals sentenced under the Pre-Fair Sentencing Act crack penalties continue to suffer collateral consequences. But there is absolutely no discussion anywhere in the legislative record that any member of Congress contemplated that this statute would allow a court to change the classification of a valid conviction. Congress was concerned clearly and consistently throughout the record. They were concerned about people serving long prison sentences. And so they enacted a targeted form of relief, which would allow a person serving a prison sentence for a Pre-Fair Sentencing Act crack offense to apply to the court that sentenced them for a sentence reduction on an individualized basis. But there's simply no evidence that Congress contemplated that this type of relief would be available. And that is reinforced by the plain text of the statute, which does not authorize the court to change the classification of a conviction.
You know, one thing that always concerns me, because I always look over my shoulder at the Supreme Court, and I've been reversed by the Supreme Court many times during my service, but I've always felt that the position I took was at least an arguable one before the Supreme Court. And in this case, I never went and put forward a position where I felt that the chances of reversal was 99.9%. And what I would say is, there are reversals where you look at it and say, well, you know, people could look at this in both ways and everything. And that's your normal reversal. But then there's another kind of reversal, which is a rude reversal. And those you don't forget, and the court doesn't forget, because the rude reversals are reputationally damaging, whereas the normal reversals are within the good bounds of reasonable and legitimate argument. And, you know, I just feel like he's inconsistent with my position as an inferior judge to sort of wing it and send up something to the Supreme Court that they would make such short work of. That's, you estimate the chances of this position ever succeeding with the Supreme Court. They're very, very slim. Do you understand the point I'm trying to make?
Yes, Your Honor, we agree, of course, and I would just reiterate that this would seriously undermine the strong presumption of finality in federal sentencing.
Can you talk for a second about assume your basic argument here is right, and the manner in which we ought to think about that from a sort of decisional perspective? Do you think that is mootness? So in other words, if this court is unable to, or I should say the district court is unable to grant relief that is being sought, that means it's no longer redressable in this criminal action and therefore it's moot. Is that the right way to think about it? Or do you think we should think about it some other sort of jurisdictional or non-jurisdictional manner?
Your Honor, I recognize that we did not press a mootness argument in the briefing, so to the.
Could you speak up? I'm interested in hearing you. Go ahead.
Sure, can you hear me, Judge Wilkinson?
Yeah, I'm just interested in hearing your answer to Judge Richardson's question.
Okay, I just started by saying that we did not press mootness in the briefing. I'm aware of that. However, the court has an independent obligation to assure itself of jurisdiction at all points in the litigation. So if the court would like supplemental briefing, the government is happy to provide that. But to get to the merits of your question, to the extent the court agrees with the government that the statute simply does not authorize the form of relief that the defendant is requesting, then the court could analogize to the Second Circuit's decision in Martin, that reasoning, as well as the other unpublished Court of Appeals decisions, which have all concluded that because Section 404B does not authorize a court to reduce a completed sentence for a covered offense, there is no further, that any injury the defendant continues to suffer from his covered offense is not redressable by the court in that way. The issue is moot. The court could resolve this case in that way.
And is understanding that this was not the manner in which the United States briefed it before, you're an officer of the court and you've thought really hard about this. And so we want your wise counsel on it too. Is that what you believe is the correct way now that you've seen these different arguments? Is that the correct way to do it? Or do you think that is not the correct way to do it? I mean, all these are assuming that you're right on the merits. This is the hypothetical, right?
Of course, I think that would be the correct way to dispose of the case because his injury is simply not redressable by any relief that this court or the district court could grant.
Thank you.
If the court has no other questions as to the First Step Act, I'll just briefly address the Declaratory Judgment Act. As the court, I'm sure, is
You
aware.
probably need to speak into the microphone for Judge Wilkinson.
Thank you, Judge Thacker.
Thank you, Judge Thacker. I appreciate that.
The Declaratory Judgment Act allows a court to declare the rights and other legal relations of any interested party. But the Supreme Court has made clear that the statute's operation is merely procedural in nature. It doesn't alter substantive rights. What the defendant is requesting in this case is a substantive change in the classification of his offense. The Declaratory Judgment Act simply does not authorize a district court to do that. Further, the requested relief would conflict with the saving statute, which preserves the penalty that he incurred at the time that he engaged in the underlying offense. If the court has no further questions, we ask that you affirm.
All right, thank you very much. Counsel, you have some rebuttal time.
Good morning, Brian Warren on behalf of the appellant. I want to start from a different position. I don't believe the government has answered the question of what relief is available to those convicted of simple possession of crack cocaine. We believe that under the government's reading, they would create a nullity in the statute, which would render it void, at least for those convicted of simple possession of crack cocaine.
It would make It would make a nullity of the statute?
At least regarding those convicted of,
What about all the petitioners who have received relief under the First Step Act? How would that make a nullity of the statute, given the large number of people that have had their sentences reduced?
and Your Honor, it's the nullity just for those convicted of simple possession of crack cocaine. Under the data that we presented, that was from the Sentencing Commission, of the 186 people sentenced
Wait,
between.
I'm sorry, sir. I just want to understand. I saw
Yeah.
this argument in your brief and frankly, I wasn't able to follow it.
Okay.
The argument is that anytime a statute doesn't apply to some category, that means it's a nullity with respect to that category. That's what a statute that doesn't apply to a category means. But we don't call that a nullity because it applies to lots of other categories of people. A statute is a nullity in a scenario where it doesn't apply it to anybody. And here, as Judge Wilkinson points out, this statute applies to lots and lots of people. Like those of us that sit up here, we see lots of these cases, and our good friends on the district court see an inordinate number of these cases. And so the fact that it doesn't cover some group doesn't make the statute a nullity in any respect.
Your Honor, it would make the entire portion of the statute that was meant to apply to simple possession offenders, it would render it meaningless for those offenders. None of them
No,
would
it
be
just would mean that the first step, I mean, I don't think you're right on the premise, but even if you were right on the premise, it would just mean that the First Step Act didn't effectively make retroactive the part of the Fair Sentencing Act that addressed that issue.
Well, Your Honor,
And
as
it still applies to simple possession offenders who have not yet completed their sentence.
and there, according to our data, that's from the Sentencing Commission, there's no individual who was convicted of simple possession that would still be serving their time at the enactment of the First Step Act. So when we look at the purpose of the First Step Act, which this court has departed from the other circuits.
Wait,
and
but that's based on your assumptions that the conviction in that there were convictions in 14 to 18. I'm trying to remember the statistics you used that you suggested, well, it was unlikely that someone would still be in prison, right? So you eliminated the people that were convicted pre-14. I don't have the brief in front of me.
2005 to 2010, Your Honor.
Okay,
So before fair sentencing.
right. And it might be that it's unlikely, right, that somebody's there. But our point is okay, but what is that? That doesn't render the whole First Step Act a nullity. It just means that it didn't effectively make that portion of the Fair Sentencing Act retroactive.
Your Honor, I would, in tandem with this argument, look at the purpose of the First Step Act. And as this court held in Collington, and has repeated from Wershing to Chambers and other First Step Act cases, that the First Step Act is a broad remedial statute intended to correct the unjust disparities between crack cocaine and powder cocaine. And this court has sought to avoid contravening that intent. And so by narrowly interpreting the First Step Act not to allow a district court to reduce an already completed sentence would be including more limitations than there are in the statute. Additionally, when we look at the text of the First Step Act, as the court noted in Collington, that the word impose allows a district court to impose a new reduced sentence. So it's not reducing this, it's allowing the court to impose a sentence that would be different from the sentence that was originally imposed, which would mean that the individual here, Mr. Payne, would be able to reduce his 5 years, 3 months, and 3 years of supervised release to a punishment that would be under a year. And speaking to Judge Thacker's point about the collateral consequences.
But you do agree that whether something is a felony does not depend upon the sentence received.
That's correct, which is why under the Fair Sentencing Act, that Mr. Payne's conviction or his statute is a misdemeanor. And so if he
Right,
were to be.
but again, let me go. This is why I asked your colleague this, and I'll give you the chance to respond to it. Right, the First Step Act doesn't make the Fair Sentencing Act retroactive. It tells judges to pretend like it is, right? And so it doesn't actually make the conviction a misdemeanor. It just tells courts to pretend like it is when you're imposing a new sentence.
Your Honor, respectfully, I don't think that's what this court noted in Collington or in Chambers. That I think it explicitly stated that the First Step Act made the Fair Sentencing Act retroactive. And for these reasons, we believe that that the Fourth Circuit should reverse the decision of the lower court. Thank you.
Thank you very much. All right. We appreciate the arguments of counsel, and we will
Your Honor, my name is Ann Reardon. I'm counsel for the appellant, Mr. Ferguson. Your Honor, the district court committed an error of law when it refused to consider all the reasons that my client submitted to be considered as extraordinary and compelling in this case. The district court misunderstood its discretion. It stated that this was a 2255, or it construed them as a 2255 and refused to get to them. McCoy tells us differently. McCoy tells us that any reason can be an extraordinary and compelling reason that the district court can consider. The district court has to consider all the reasons. They don't have to qualify. He doesn't have to agree with them, but he at least has to consider them. The government, in this case, is
Would
asking.
Mr. Ferguson have raised the reasons he raised before the district court in his compassionate release motion? Could he have raised those issues on a direct appeal?
Yes, Your Honor, some of those he could.
Did he?
Some of those he did.
And some he,
And some he did not. Some
right.
he did not.
All right.
Yes.
So those that he did have already been rejected on direct appeal.
Some of those have, yes, Your Honor.
Could he have raised the issues in a 2255 petition?
Not all of them, Your Honor. He could not have raised them.
But some of them he could have.
Some of them he
And
could have.
did he?
He didn't, I don't believe he raised all of them.
Okay, so-
And I can't tell you exactly.
So
which
for
ones.
those that he raised in 2255, those have been rejected.
Well, Your Honor.
And
that's-
those that he didn't are out of time. Is that
they're out of
correct?
time. Some are out of time, yes, Your Honor.
So isn't this argument for compassionate release just a workaround of what he couldn't accomplish via direct appeal in a 2255 petition?
No, Your Honor, because a compassionate release motion is a distinct and separate statute from a 2255. They're very different.
And you said that some of the arguments had been
excuse me,
raised.
Judge Thacker, go ahead. Go ahead.
Oh, I'm sorry. You said that some of the arguments hadn't been raised before. Which arguments had not been raised in a direct appeal or habeas
I
petition?
don't believe he raised the one that we raised under O'Brien. I'm not sure. I don't believe that was raised. And also, I don't believe he could raise the argument that was raised in Spencer, United States versus Spencer, which was about whether or not the improper application of the guidelines. I don't think that could be raised in the 2255. But Your Honor,
But
what
it could have been on direct appeal.
could have been?
Okay, but it wasn't, or he lost one or the other.
But Your Honor,
I think, did you have a question, Judge Wilkinson?
No, I did not. What was it?
I just thought you had a question.
Your Honor,
Oh, I did have a question. It was to follow up on your question the thing I've never been able to figure out is why this is anything other than a successive habeas petition. And they call it artful pleading, but it's not it's just transparently disingenuous pleading. But the fact you say, well, the First Step Act is a separate statute from 2255. But where does that get you? That doesn't mean that the whole scheme that Congress set out of direct appeal and petition for certiorari and collateral review was somehow set aside. There's nothing in the First Step Act or in the notion of compassionate relief that indicates Congress just wished to chuck and jettison all of its prior carefully elaborated handiwork in 2255.
Your Honor,
It's just an excessive habeas petition. You're just bypassing all the limitations that Congress has set forth.
Your Honor, we do not agree because it's not as excessive. There are two different schemes or statutes with fundamental differences. A 2255 challenges the validity of a sentence, but a compassionate release does not challenge that conviction. 2255 is based on error, but a compassionate release is based on discretion. The court can still deny it.
But you're raising errors in your conviction. You have raised Fifth and Sixth Amendment claims. And all of those had to do with errors that led to your conviction. And I thought that the compassionate relief was to speak to developments that were after the conviction, post-conviction, that didn't have anything to do with the soundness or the validity of the conviction.
Your Honor,
And the chief one of those is, that I've seen raised is the individual's age and the individual's health, and maybe the length of service. Those are post-conviction developments. You're raising an argument of validity of the conviction based on Fifth and Sixth Amendment grounds. That's a different kettle of fish.
Your Honor, the guidelines, the Sentencing Commission guideline itself says that the foreseeability of any condition does not mean that it is barred from being raised. This is a totally different statute based on discretion. It's a narrow exception to the rule of finality. And there's such a high standard of with the extraordinary and compelling criteria that prevents the rule being swallowed up by the exception. And additionally, Your Honor, at 28 CFR 944T, the Sentencing Commission is charged with, quote, shall describe what shall be considered extraordinary and compelling reasons for sentence reduction, including the criteria to be applied and a list of specific examples. Government's bright line rule where they want you to say what can and can't be considered in a motion for compassionate release is going to effectively hogtie the Sentencing Commission, because the Sentencing Commission now has a quorum and now is going to answer this.
Well, of course, the district court can consider a motion for compassionate relief. The question is whether in the course of that consideration, the district court is also empowered to look at the substantive constitutional claims, the Fifth and Sixth Amendment claims, that you say renders your conviction infirm.
Your Honor,
and of course, as has been pointed out, you had numerous attempts, and in fact, you have had numerous attempts to attack your conviction. My gosh, they go on and on and on. And all of a sudden, because those numerous attempts were unavailing, you've gone into a compassionate release mode. And there you seem to me to have to deal at least with the guideline in 1B1.13, which says presumptively compassionate relief or extraordinary and compelling reasons are when somebody is 70 years old and has served at least 30 years in prison. I don't think that's the only reason, because I think if someone is in a dreadful state of health, that, you know, that might be another matter, even if you're less than 70 years old. But I don't, I just come back that after years of failure, you have decided to latch on to this new vehicle. But the fact that you have been unable to obtain relief through the normal habeas process and the normal 2255 process doesn't mean that you've established extraordinary and compelling reasons for this whole altogether different vehicle.
Your Honor, the court has to look at that. There are many cases that, in fact, the First Circuit just looked at this issue in two cases, United States versus Trinkler and United States versus Uvercabla. And they both said that they were both characterized by the government as a 2255. And in both of those cases, the court gave relief, stating that this is a different statute. And so you have to take a holistic approach to this and look at what they described as the complex of circumstances. It requires an individualized approach. Under this bright line rule that the government wants the court to adopt, basically means that no one who's ever filed a 2255 or Rule 60 can file a motion for compassionate release. And we know that's not what happens.
Are those two First Circuit cases you just mentioned, are they in your briefs?
They are not, Your Honor. I am sorry, they are not. I can give you the sites for those. I'd be happy to do that.
Yeah, that would probably be helpful since they're not in your
I'm
briefs.
sorry. And I found them just recently. You want sites now or?
You can, I think a 28J letter afterwards would suffice and would give the government fair opportunity to respond to things you're raising for the first time today.
But there in McCoy had filed 4 previous 2255 motions, and they were not, his complaints were not deemed to be as successful as the 2255.
But the difference in McCoy is that none of those issues were like plausibly raised on direct appeal or collateral attack, right? I mean, those are, my sentence is really, I mean, you know, what the court says is the extraordinary length of the sentence, right? And that is, despite sometimes the claim, that's not an issue we address on direct appeal, right? Your sentence is lawful and reasonable, but it's just really long. And that there's a non-retroactive statute that if you were sentenced today, you would receive a lower sentence, but has no applicability to your sentence. Those are non-cognizable either on direct appeal or 2255. And so McCoy says, you know, those types of things, right? Those are effectively policy arguments, right? For why you should get out of prison. Yes, those are things that a court can consider, but it's not to say that you get an end run around the limitations of habeas. And we say the same thing in the context of like Rule 60 motions that attempt to circumvent habeas limitations.
Your Honor,
We have a whole line of cases that say you don't get to do that. Yes, Rule 60 is a different rule than Section 2255, but that doesn't matter. You don't get to do the end run. Help me understand why. I don't think McCoy helps you, and it seems like to me the cases addressing Rule 60 undermine your idea that like as long as there's a different number, it doesn't matter.
Your Honor, one of the reasons in this case is the extraordinary long sentence that my client received. He received 765 months, which was reduced to 622 months. And that's one of
had he argued that the extraordinarily long sentence that I received is a reason that is an extraordinary and compelling reason. It strikes me that would be something that the district court was entitled to consider. That's not the argument he made.
Your Honor, he did make that argument. I'm sorry. That is one of the reasons.
That's not okay. He included that, but the point we're talking about is whether you can consider these habeas-based issues, right? Which are the silencer issue, the legal changes, right? And the changes in the law, as you're alleging them, what I would say is collateral attacks on his conviction and sentence. The question is whether those can be considered.
Your Honor, I believe they can be considered as part of the whole. That's not, we're not asking the court to rule on that or to say that those convictions were invalid, but that's part of the whole. He also, besides the extraordinary long sentence, he was a criminal category 1. He had only had a prior conviction for carrying a weapon. It was found in a vehicle when he was on government property up in DC. He received a $50 fine. That's all that he had for that, Your Honor. We also pressed claims of his health, which the court did. That was the only reason that the court even looked at it. Refused to even look at the rest. It didn't look at his rehabilitation. He's been in prison for 17, 18 years. He's never had one infraction at all. And he has taken classes. He has family support. He has a release plan, Your Honor. And also the disparity of sentences between what he got and what his co-defendants got. The most that one of them received was 420 months.
But then you're just getting back into those are all arguments that are available on direct appeal, right? So the 3553A factors weren't appropriately calculated because there was a disparity in sentences, right? That's exactly the type of issue like ineffective assistance of counsel that's raised on 2255. Right. So what I'm trying to get at is, at least for those categories of things, it seems like our case law is suggesting in the Rule 60 context that you don't get to use a different number or different rule or different statute to bring those habeas or direct appeal challenges.
Your Honor, they are brought part and parcel as part of the package of these are extraordinary and compelling reason. And that is just a narrow rule. It's a very high standard. And as the court stated in the First Circuit in Ruva, I can't pronounce that you look at this whole complex of circumstances, and one alone may not be enough. The court could say no, that you've already had that chance, or maybe two are not enough. But when you put them all together, that it can comprise a motion for compassionate release. So you have to look at everything that the defendant has to offer.
No, but the point is, the words are extraordinary and compelling reasons, and we have there's a general agreement on the extraordinary and compelling reason standard. But the question here is, it is not an extraordinary and compelling reason that other attempts through collateral review and through habeas have failed. That's not a compelling, and the fact that you were unable to achieve relief through some other vehicle is not an extraordinary and compelling reason for compassionate relief. Because if it were, we would be sanctioning a complete circumvention and a complete end run around 2255.
Would you, my time has expired, would you want me to?
Yeah, well, you have some rebuttal.
May it please the court. I think there's a very important passage in this court's opinion in McCoy that really lays the foundation for why the defendant's functionally habeas claims should not be a basis for finding an extraordinary and compelling reason for compassionate release. In McCoy, this court said that the, quote, very purpose of the compassionate release statute is, quote, to allow for sentence reductions when there is not a specific statute that already affords relief, but extraordinary and compelling reasons nevertheless justify a reduction. The claims that the defendant is pressing that are attacks on his conviction and challenge do have a specific statute, actually statutes, that provide a remedy. And that was not the case for the change to the stacked 924C penalties that was considered in McCoy. Both direct appeal and 2255 provide an avenue for relief. And when you look at the mechanisms that those statutes provide, they underscore the incompatibility with using compassionate release. For example, the defendant here has a claim that his attorney failed to subpoena a witness from a halfway house. That's a claim that doesn't translate into some sort of a fixed sentence reduction. If it's a successful ineffectiveness claim, you get a do-over of the proceedings, which then could lead wherever the new proceedings go, it doesn't make sense as a sentence reduction. And so in harmonizing the statutes, it makes perfect sense that when you have claims that are subject to direct appeal and 2255, those mechanisms should be used, and the compassionate release statute isn't an end run around them. And you see that in this court's cases about, for example, in the Supreme Court's cases about Rule 60, Federal Rule Civil Procedure Rule 60, and how it is harmonized with the limits on 2255s, including here successive limits. So I think that passage in McCoy really goes to the heart of the problem the defendant has here. And the DC Circuit's recent opinion in Jenkins, which collected cases from the 7th Circuit, the 8th, the 6th, the 10th, and the 3rd, some albeit unpublished, are in harmony with that. I am familiar with the First Circuit's opinion in Trenkler that counsel has cited. And in a nutshell, that's simply wrong. And the First Circuit doesn't have the reasoning that this court has in McCoy, where it said that compassionate release is to allow for sentence reductions when there's not a specific statute that already affords relief. And that logic from this court fits perfectly with the overwhelming weight of authority that the DC Circuit and Jenkins.
Can you help me understand the rule that you're proposing to sort of distinguish this case from McCoy, right? So I can think of a couple possibilities, but I'm interested in your take on where the McCoy line is between sort of that instance of an extraordinarily long sentence and a new statute which reflects a societal judgment about the appropriate length of sentence for that type of an offense. And the claims, at least that are pressed on appeal, she talks about a long sentence. That's not something she presses on appeal, but the claims that are pressed on appeal, which are ineffective assistance to counsel, the Alene line of cases, sort of the procedure that you need to submit it to a jury or not, those types of direct or habeas appeal cases or habeas appeal issues, how would you have us define the line between those two?
The way that I would define the line is that claims that attack the validity of the underlying sentence and conviction should be pursued through direct appeal and habeas, that those are the mechanisms. And in McCoy, the statute, the change in the 924C penalties that the court was considering, this court in McCoy recognized in the earlier opinion, Jordan, that the way that statute applied was that it only would give relief when you had a sentence that had not been imposed. And so in a defendant's case, where there was a long final conviction, then, and nothing that upset that conviction and sentence, there was no error. And so that's I guess if I were boiling it down, I'd be like, McCoy was dealing with a defendant who had a sentence where there was no error. But he was saying, look, they've changed dramatically the statutory penalties, and you should factor that into as an extraordinary and compelling reason. And McCoy said, you can do that. McCoy did not say, McCoy specifically said, if there's a specific statute that affords relief, then you've got to use that. And the compassionate release statute has to be read together with those statutory mechanisms, and they're not at war with each other. And I think that's exactly right. And so
is that another way of, I just want to make sure I'm understanding the rule here that you're proposing. So attack the validity of the conviction and sentence.
Right.
Is that different or the same as saying it's cognizable on direct or habeas review?
I think that's the same. And as to the conviction challenges, I would say there's a harmony with, for example, in Your Honor's opinion in Webb, and you were discussing a 404 motion, that a defendant who is seeking in a 404 motion to challenge his conviction, that just doesn't make sense as a basis for a sentence reduction. Or Judge Thacker, an unpublished case that you were sitting on earlier, George, last year, which was a defendant saying, look, I'm really not guilty. I should have a reduced sentence at sentencing because of that. Courts don't do that. Once you get to sentencing, the validity of your conviction is final. There are methods to attack your conviction, but when you're talking about a sentence reduction, we treat as given that you are guilty of the offenses that the court is about to sentence you for. And so those are a really clear example, I think, of where it does not make sense for compassionate release to be incorporating conviction challenges. But the same, I think, is true of these sentencing challenges that are ones that, as McCoy says, there are other specific statutory procedures to make those claims in direct appeal in 2255. And then I just go back to what we were discussing a moment ago.
Are you saying that the an error in a conviction is per se not an extraordinary and compelling circumstance, or that it generally is not an extraordinary and compelling circumstance? Or are you saying that as a per se matter, attacks on the validity of the conviction or the particular sentence need to be raised through the normal processes of 2255 and direct appeal, certiorari, and habeas?
I would say as to compassionate release, attacks on the conviction, it's a per se, you shouldn't be considering them. Now, I hasten to add that there are an abundant number of means, well-developed means for attacking your conviction. And so I'm not saying you can't do that as a defendant. Of course you can.
Right. So you're not advocating a crack in the door that says, well, if there's an injustice here, you can consider it, or what have you. You say you establish the injustice in habeas and get the specific forms of relief, or the forms of relief in habeas may differ from the form of release and compassionate release. They may not be the same thing. It's not just the channels you go through, but it's the form of relief that might be available. But you're arguing that these two vehicles should be kept as separate as possible, because that's really what Congress intended, that Congress cannot have expressed compassionate release statute to suddenly just toss and chuck overboard all of those very finely tuned criteria for being able to bring a successive habeas petition. And the Supreme Court has, has emphasized the importance of 2255 and not circumvent it by artful pleading. So you're saying to us, please keep these two vehicles separate. Is that correct?
Exactly right. And I think you can see it both in terms of the conflict in the statutory provisions, but you can also see it in terms of the remedy. For many conviction challenges, the remedy is a do-over the proceedings. It's not a sentence reduction.
Yeah, you have a remedy in habeas. It's very different, because then you have a retrial. Very often it's a retrial, but when you deal with compassionate release, that's a very different remedy. Someone gets released. And also there's a completely different temporal dimension, it seems to me, and that is that habeas is meant to test infirmities that led to the conviction, and that habeas is meant to test errors in a sentencing proceeding or test errors through ineffective assistance of counsel. And the compassionate release statute is designed, and its focus is on a completely different temporal segment in the criminal justice process. And that is what developments and I would say health, for example, and length of service is among the chief of those. But what kind of post-conviction developments have make out a case for compassionate release? Part of it, I think, would be someone's conduct while in prison. Another part of it would be the length of time that someone served and at what time, at what age they're going to get out. Another would be what kind of conditions, health conditions someone is suffering. And those are just a different set of inquiries from habeas corpus, and they have a different set of procedures and they have a different set of remedies, but they are separate vehicles.
I agree with that. And I think the court understands the government's position. I'm happy to address any questions the court has, but otherwise I'll ask that you affirm.
Counsel, you've got some time for rebuttal.
Yes, Your Honor. My client did press those claims in his motion, but the judge refused to look at them. He pressed the claim of the extraordinary long sentence and the criminal
So
history.
can you point to me in your appellate brief where you allege the district court erred in considering the claim that was expressly made by your client that that unextraordinary and extraordinary and compelling reason for compassionate release was his long sentence? Because when I look at your brief, I just don't see that.
I would have to look for it, Your Honor.
That'd be great. I mean, because the headline, I mean, you can start by looking at the table of contents, and none of those say the district court erred by failing to consider the argument that he had a long sentence. No, I understand the argument that that maybe it was raised in the district court in some manner, but we review the errors that you give to us. And when I read the argument here, right, they fail to consider the legal arguments, right? And that's the focus of the briefing, which is why it's sort of been the focus of the questioning here.
Well, talked about how the guidelines were misapplied, which led to the extraordinary long.
I must say, if you didn't raise it, I can understand why, because errors in sentencing, this is not a redo of a sentencing proceeding. That errors in sentencing can be raised on direct appeal. And my goodness, how many times have we reversed district courts for an inadequate explanation or for an unreasonable substantive, there's substantive unreasonableness can be raised on direct appeal. A failure to consider a defendant's mitigating evidence. But you have a whole host of things that amount to procedural unreasonableness and substantive unreasonableness. And there's a vehicle for raising all of that, and that is on direct appeal and on habeas. But that goes, it seems to me, again, to the separateness of these two proceedings. So I can understand why you wouldn't be raising that kind of question. I might say, if what we're talking about here is an absence of process, as I've seen it, I don't see a whole lot of cases where someone has had the ability to raise has brought has so many challenges. Ferguson has had multiple opportunities, including new trial motions in 2005, 2008, and 2009, direct appeal motions for sentencing reductions in 2008, 2016, 60B motions for under 2255. If what we're talking about here is some unfairness in the criminal justice system due to an absence of process, the number of proceedings that this frequent litigant has brought are astonishing.
Your Honor, may I respond?
Yes, you may.
Your Honor, in the, when I'll submit to you the First Circuit cases, and in one of those cases, that defendant, it was the same charge, it was a 2255. He had been before the court 9 prior times, Your Honor. The issue here is that the bright line rule that the government is trying to impose is in opposite to the purpose of the statute, which is to grant relief. It's one based on discretion, and it also would violate 28 CFR 944T. This issue was discussed by Judge Smith in the United States versus Spencer, who said that the defendant was able, she did not grant relief, but she at least considered the reason, Your Honor, because she said that the defendant could not get relief under 2250.
No, the government is, all the government is saying is that these are very separate mechanisms, and it is important that they be kept separate because they have a different set of ground rules, and they have a completely different set of standards and a completely different set of remedies. And it's important to not have everything scrambled up with everything else. But I do think you've made your points, and I appreciate it. And if my colleagues have no questions, I would like to thank you for your argument.
Thank you, Your Honor.
Thank you. All right, we have our
Please report. Jennifer Bennett on behalf of Sergeant Davidson. Congress passed the Military Lending Act because lenders were targeting service members with predatory loans, including, in the words of the Defense Department at the time, unscrupulous automobile financing. Congress and the Defense Department's concern was not just high interest loans, but again, in the words of the Defense Department at the time, loans that were packed with excessive fees and ancillary products. And especially concerning was that lenders were taking service members' cars as collateral for these loans, putting what is often service members' only real asset and only mode of transportation at risk. United Auto's loan here is precisely the kind of loan Congress sought to regulate by passing the Military Lending Act. It's packed with charges, including an unexplained fee, undisclosed interest, and GAP, or Guaranteed Asset Protection Coverage, which is a financial product, not a car product. It's usually available for less when you buy it separately from a car loan. And it only kicks in the rare circumstance in which your asset is totaled and you owe more on a loan than you have left on insurance, or rather than insurance coverage pays out. There's no dispute that all of this financing would ordinarily be subject to the Military Lending Act. But what United Auto says is, well, hey,
Is gap coverage inherently predatory? What's wrong with gap coverage?
Your Honor, it's not necessarily inherently predatory. We do think it has limited value in certain circumstances, which is when you have a loan that is going to far exceed the
So
value.
why shouldn't someone be entitled to purchase gap coverage when they're also purchasing a vehicle? Those two go together, don't they?
Your Honor, we are not arguing that the Military Lending Act or anything else prevents someone from purchasing gap coverage when they're purchasing a vehicle. The only question is if they take out a loan to purchase that gap coverage, that loan would ordinarily, there's no dispute either that loan would be subject to the Military Lending Act.
Isn't it also fair that the military is sort of a little bit unique, that the military is an employer that requires its employees to pay their debts? And so if you're unlike, maybe in some circumstances where the debt might not be ultimately collectible in some non-governmental settings, the military is quite good about ensuring that its soldiers pay their debts. And so it strikes me that gap coverage, to the extent it's useful anywhere, seems most useful in this context.
Your Honor, I'm not sure whether that's correct. And there's some facets of the military that make gap coverage particularly unuseful, particularly that service members sometimes take their cars overseas, and gap coverage is typically voided in that circumstances. But whether gap coverage is beneficial or not is irrelevant to this question, which is simply,
what's the point of the Military Lending Act? Isn't it I thought it's to prevent predatory lending, or to prevent predatory lending.
That's correct. And so the question is just, if you take out a loan for gap coverage, the question here is, there's no dispute that if
where's the predatory lending in this situation?
So in this situation, it's by combining the coverage with the purchase of a loan. And so for a car,
it's the gap coverage combination that makes it predatory, right? Is what you're saying, that makes it fall within the Military Lending Act, correct?
Your Honor, the Military Lending Act, in fact, tells us what falls within the statute. And what it says is that the only things that are exempt, lenders can never take service members' cars as security for a loan. And these sorts of ancillary products, excessive fees, there's undisclosed interest in this loan, any sort of thing that you can package in with a loan. But the Military Lending Act has very specific regulations about how you can do it.
Do you mind turning just for a minute? You started off, so we responded to you. You started off talking about broad purpose and what was intended to be done here. And we typically start instead with the text for good reasons, I think, because we can have realistic disagreements about what purpose might have been here. Can you help me understand the phrase "the express purpose"? It strikes me that there are two plausible interpretations of that, or at least possible. You don't have to concede they're plausible, but they're two possible. One sort of specific and identified, and the other is sole and only, right? And those are two possibilities, and you and your colleague disagree over which one applies here. And I guess what I want to ask you is to comment on this idea that the difference of those depends upon the nature of the statement in which the express purpose is included. And so where the express purpose is included in a directive, right? A loan must be used for the express purpose of purchasing a car. That means only, right? Because it's a directive, but is instead where it's a condition, right? Is the loan offered for the express purchase of a purpose of buying a car? Then it need not be only. And I'm going to give you a hypothetical, and I know this is a long-winded answer, and maybe Judge Wilkinson will give you some grace and let you run over a little bit because I'm long-winded. But if I give my law clerk over here $20 for the express purpose of buying a sandwich, he then goes and buys a sandwich and a book, then he's violated the express purpose because that's a directive. The express purpose is the directive. But if instead I give him $20 and tell him, go buy a book and a sandwich, and when he gets back, his co-clerk asks the conditional question, did the judge give you $20 for the express purpose of buying the book? the answer there seems yes, not no. And you want to say the answer is no, because there can only be one. And I gave him two purposes. Does my hypothetical make sense?
Yes, Your Honor, I think so. And I think what you're pointing at is there are two, I agree, there are two possible meanings of the word express. And I also agree that the way you figure out which one the statute uses is by looking to the text of the statute, its structure, and its purpose. Now, I think if I understand your question correctly, I think what you're saying is in all purposes, if the statute is a directive, that means exclusive. And if the statute is something to do with the purpose of the loan or the transaction, that should mean
It's a
explicit.
condition, right? The difference between a directive and a condition.
Correct. I think that's, I think there are statutes, for example, we cite the Sugar Act of 1937 on page 26 of our brief, where I think it would meet what you're saying is the description part, prong, which says, if you, it's excluding, just like the Military Lending Act, an exemption from the statute, and the statute was about quotas for sugar importation, and it's excluding from that quota importation that's for the express.
Let me make sure that I understand your argument on this express purpose of financing. Let's say that the lender says that this is for the express purpose of buying a car, and stamps that on the loan itself. This is for the express purpose of purchasing a car. And then included within the a law are charges for car washes and gap coverage and other things that may have some related, but it's a bundle situation where I guess it's all or nothing. That the loan, you don't have the borrower doesn't have the right to sort of separate, saying I want this but not that. Is that correct?
I'm not sure I completely understand your question. So if I'm not answering it, please let me know.
Well, I guess what I'm saying is that I don't think that the label that the lender puts on the loan is dispositive.
Yes, Your Honor, I think that's exactly right. But that is the result that would happen if what we said is express in this context just means explicit. Because then all a loan would have to say is that it's a car loan and it would be exempt. And this would be a problem.
Right, and you could smuggle in all kinds of things.
That's exactly right. And
But the thing for the express purpose, it says they're looking at the text here of financing the purchase of a car, and I'm not sure that the purchase of insurance is for the purpose of, as for financing the purchase of the car. The insurance doesn't even come into play unless the car is totaled. And that event is well after the purchase. I know when I go to an automobile dealer, I don't want gap coverage because it's more expensive, often when it's combined. I want to buy the insurance through my insurer. And one of the big differences when you buy these things through an automobile dealer and take that loan, you have to put up the car as collateral. And when I'm purchasing gap coverage, I don't have to put up my car as collateral. All I have to do is pay the premium. And so there are ways, I think, to take advantage of servicemen by having gap coverage actually more expensive than it would be to buy insurance on the open market. And I think that's the answer I might give to Judge Thacker's excellent question. that there are ways to smuggle these add-ons in and stamp the label, well, this is for the purchase of a car, when it's not. I mean, they can still offer gap coverage, they just are subject to the MLA. But at any rate, that's what I was trying to get at, is these add-ons can be predatory, but maybe Judge Thacker or Judge Richardson has further questions of you. And
If you don't mind, Judge, can you go back to the distinction that I was trying to get at? Because I don't think your sugar example works. Because there it's the express purpose of the exportation of the equivalent amount. And so I don't think they're the express purpose. It actually doesn't suggest that it has to be the same, because equivalent amount means that you could use different sugar. So if you bring in with hand A and export with hand B, but instead of spending our time fighting that example, do you have any other example where it's express purpose means sole when it's used as a condition instead of a directive, right? Because when I see, I mean, I could give you a number of examples where a conditional use of express purpose means specified or identified, but I haven't been able to find one where it is a means sole or only. Like the sugar example, that seems to come from equivalent and actually seems to undermine your use of express purpose there.
Well, so you know, in the sugar example, the question is could you have it for the express purpose? Could you label what you're doing with the sugar? I'm exporting an equivalent part, but instead you aren't. You're keeping the sugar, or you are exporting part of the sugar. So, but there are a number of statutes cited on pages 26 and 27. And I'm actually not aware of any statute, and United Auto doesn't cite one, where for the express purpose of would allow you to use the loan or the financing for any other purpose. And I'll note that
right, but most of these, so the ones that you cite when we start talking about the Secretary of Interior, they're directives, right? And so this is what I'm trying to get as this distinction between a directive, right? You shall use this for the express purpose of X means only for X, right? In contrast, if I'm asking the question where there's a dual purpose and I say, was this done for the express purpose of one of them? The answer is yes. Was it done for the other one? Yes. Was it done for both? Yes. All of those would be satisfied in that context.
So two answers to that. I think what you're getting at is perhaps there is it's not clear a priori what this necessarily means, which means then that we turn to the text and the structure and the purpose of the statute. And so the statute says there's 3 requirements to be exempt. It has to be procured in the course of buying a car rather. It has to be secured by the car.
But, so do the first one for me. And Judge Wilkinson, I apologize. I asked for a little grace. The first one, you're not arguing that the gap coverage wasn't in the course of procuring a car.
No,
okay,
no,
all right.
but so it has to be procured in the course of a car, and it has to be secured by a car. And if
both of those are true,
both of those are true right here. But if what we're saying is the loan just has to have as a purpose written down that it's for a car, that whole phrase is superfluous. It does absolutely no work, because any loan is that's procured in the course of purchasing a car. Anytime you go to a dealership and get a car loan, it's going to say it's a car loan. So that whole phrase would do no work if all it means is it has to say it's a car loan. On the other hand, if you give what I think United Auto concedes is an equally well-used definition of express to mean precise and exclusive, if you give express that definition, then all of a sudden that whole phrase that Congress put into the statute for some reason has purpose. And the purpose of that phrase is that, over and over again in the legislative history of the Military Lending Act, if you look at the text of the Military Lending Act, one of the purposes given for that statute is to prevent what Judge Wilkinson was talking about, which is piling in a bunch of fees and products into a loan that's really for something else.
One thing I want to follow up with my friend Judge Richardson's question as to the question of whether it's multiple purposes or The question of whether it's a directive or not, I understand your position to be that the words express purpose are pretty much are in itself a directive. It means for one and only one purpose and for no other. And it's the language of exclusion, and express purpose is Congress is, it might have said you shall, but it did say that with the words of express purpose. And of course, there's another maximum of statutory construction, and that is the exceptions to a statutory purpose and language should be read narrowly. And it wouldn't read things narrowly to say that there's a lot of, that all kinds of bundling can go on. And just because the lender labels it for the purpose, that's artful labeling. We talk about artful pleading. This is art. It's just a question of statute being to protect the servicemen, and with disclosures and other safeguards. If you're ever in a military base and I only served in the Army Reserve, but I've been to Fayetteville and Louisville and places, and you go right outside of the base and you go into town. There are so many businesses that want to take advantage of the military and people who are service members. And it's almost like they just can't wait, whether it's payday or whatever, but they just can't wait to subject members of our armed services to predatory terms. And Congress, with the support of the Department of Defense, wanted to address this very unfortunate development. At least that's what I think is going on.
Yes, Your Honor, I agree with all of that. To your point about directives, I do think this is a directive. The Military Lending Act says you shall not take a service member's car as security for a loan unless, among other things, the express purpose of that loan is for financing a car. And I think, Judge Richardson, if they wanted to say something different, it could have said for a car loan or for an express purpose of purchasing a car or involving a car. There are a number of formulations it could have used to signify that it wasn't meaning sole, but it didn't use any of these formulations. It specifically said for the express purpose of purchasing a car. And I see I'm way over time, so.
Well, no, that is not, that's not on you. Are there any other questions? Judge Richardson, I know you had the other questions. You have some more questions? Have you had a chance?
Thank you very much, Judge. I appreciate the time.
Sure. Judge Thacker?
No, I think she has rebuttal time, though.
Okay. Thank you very much. And let's hear from, let's see, I think it's Ms. Mayor. We'd be glad to hear from you. You're representing the United States, I understand.
Yes, Your Honor. May it please the court, Anna Moen on behalf of the United States. I want to pick up just quickly on a thread of what Judge Wilkinson was saying earlier. We think the key here in terms of the language of the statute is the focus on the purpose of the financing being the purchase of the car and what we would ordinarily think of as a part of the purchase of a car. There are a couple of different factors that you might think of in trying to figure out whether a loan fits that requirement or not. The first could be whether the product is necessary to obtain or gain possession of the car. This could be something like sales tax. If that's a part of a loan, that's something that the state requires the individual to pay in order to obtained the car. So that would not, you know,
No,
bring.
it's just the optional stuff that you are, the add-ons and the optional stuff that you're concerned about. Let me ask you one other question, and that is, this statute was passed with the strong support of the Department of Defense, which wanted to look after the interest of servicemen, and these predatory loans were sapping military morale. And has the Department of Defense taken a position on this question of bundle loans?
Your Honor, in general with bundled loans, yes, the Department of Defense took a position in the 2016 interpretive guidance. The specific question raised there was with respect to personal property and bundled loans that contain cash out financing, as well as a loan for financing of personal property. But the Department of Defense believes that the logic that underlied that interpretive guidance and that involves the interpretation of that portion of the exemption applies equally here. So when you're talking about a hybrid.
Well, do we
loan-
have an explicit statement from the Department of Defense to that effect?
Your Honor, by filing this brief, the Department of Defense strongly concurs with the position that we've taken in this brief and believes that a hybrid loan.
So this brief is the definitive position. There's no definitive position before this brief.
Your Honor, there was the 2017 interpretive guidance. That guidance was withdrawn out of an abundance of caution. The Department of Defense.
You don't argue that 16 or 17 guidance is entitled to any, Chevron type weight. They're just interpretive rules. We can consider them to the extent they're persuasive or not.
That's right, Your Honor. I don't understand anyone to be arguing there's a difference.
Do you mind commenting if you can on this idea? And I understand you want to focus on the purchase piece, but I think that turns back to the express purpose and whether in a conditional context, whether we're asking if something applies, whether the express purpose can really mean only or sole, that we don't think of it that way. I haven't been able to find an example where in a conditional context, it's been referred that way. Do you understand the distinction I'm trying to make? And can you just comment on it from the United States' perspective?
I think so, Your Honor. I think I understand the distinction, but to take a step back, I think even if we take the definition of express as specifically intended or something along the lines of what United is suggesting, that still just shows that the focus of the purchase is the purchase of the car itself. So I think even under that definition, our reading still stands. And I would also just note that
so it can be the focus without being the exclusive focus, right? I mean, that's the sort of point of it being a specified instead of sole, is that it can be the focus. I'm not sure why that matters, frankly, but okay. Without being the exclusive focus.
Your Honor, I think there are a couple of problems with the idea of just the purpose being listed. One, I don't think even United embraces the extreme implications of that position. Later in the brief, they appear to sort of switch to a kind of but-for type test. And I think they don't embrace that idea that simply writing something, stamping something on the
You can't
loan.
just say it. So I agree that, Judge Wilkinson's hypothetical that they stamp, this is for the purchase of a car when there's no car involved, right? The fact that you say it's a car loan, if there's no car involved, that doesn't do you any good. Okay, fine, right? It's not just the words. It actually has to have that purpose. So there's got to be money and a car, right? We understand what the basic idea of a purpose is. The question is whether it has to be only that purpose.
Your Honor, I think even with the money in the car and the stamp, all of that together, I think you still face the problem that Judge Wilkinson identified, which is that would allow a lender to bundle in cash out financing and therefore subject this service member to additional interest.
That might be a terrible idea. I'm totally with you, right? But I want to sort of bracket just for a minute all the various policy arguments that one can make as to whether this was a good statute or not. When I look at the words of the statute, that's where I'm sort of having trouble because I can't find an example where anybody uses the express purpose in a conditional statement to mean exclusive, right? The Supreme Court repeatedly uses the term express purpose. And when it uses it, it does not use it in the conditional context to mean the only purpose. right? And so when we look at the words in a conditional statement as opposed to a directive, I don't see it being used to mean what you think it means.
Your Honor, I don't think I can sort of more helpfully answer that question because I'll
That's
just say
good.
I don't have an example off the top of my head that
Thank
reflects
you.
that. But I think my time is long expired, so.
Well, the word express purpose has a very clear and crystallized meaning in the context of this statute, which the statute was to protect service members from predatory loans. And when you look at the words express purpose, it falls in line. You have a situation where I think text falls in line with purpose in making this the one and only object. It's entirely fair given what this statute intended to accomplish, and given the very focused, crystallized, it's a laser beam statement about the express purpose. That means carloads. I mean, I point out you can make these loans for gap coverage or anything else as long as you make the proper disclosures to members of the military. Just tell them what you're doing. Don't put it, don't hide it under the table or do the things that the Military Lending Act was designed to prohibit. And as I say, what we would be doing is we'd be reading an exemption into the statute, and we're always told that exemptions ought to be very, very narrowly read, and that's what makes me nervous about the appellee's position here. Is that we're taking the clear purpose of Congress, very strong language, implementing that purpose, and reading an exemption to the very things that the statute aimed to prevent. And that's troublesome.
Your Honor, I completely agree with all of that, and I'm well over my time, but I would just conclude by saying that if there's any sort of ambiguity in thinking through the various constructions, that's precisely where the DoD, in consultation with financial regulators, is empowered to rulemaking and to fill gaps. But with that said, thank you.
All right. Thank you. Is it Miss Black? I would be happy to hear from you.
Thank you. Good morning. My name is Stacy Blank, and I'm here today on behalf of the appellee, United Auto Credit Corporation. The district court correctly dismissed Mr. Davidson.
You might speak in the microphone. It's a little hard on the system to hear if you're not speaking right into it. I know it's hard. Thank you.
The district court correctly dismissed Mr. Davidson's complaint in this case because under the plain language of the statute and the implementing regulation, the extension of credit that United Auto gave to Mr. Davidson was exempt from the MLA. The MLA does not apply, as we've discussed, to a loan procured, one, in the course of purchasing a car, when the loan is offered for the express purpose of financing that purchase, and two, when the credit is secured by the car. The implementing federal regulation likewise excludes from the MLA any credit transaction that is expressly intended to finance the purchase of a motor vehicle when the credit is secured by the vehicle being purchased. Mr. Davidson's allegations in the second amended complaint, along with the retail installment contract that was attached to that complaint, demonstrate that United Auto's extension of credit to Davidson was made in the course of his purchase of a car. It was for the express purpose of financing that purchase, and that his credit was secured by the car he purchased.
Well, the textual argument that you're making here it sort of runs a cropper of what the district court said, because in reading the district court's opinion carefully, it uses all sorts of words like related to the purchase of a car or involved with the purpose of the car. And the district court seemed to me, by the use of words like related to and intertwined with and involved with, wrote a gloss on the statute. And whether the district court's view is right or whether it's not, to me, it's just a matter of textual interpretation, and Congress words related to or involved with the purpose of a car or directly related to the purpose to the purchase of a car, and it just seems to me that a gloss was written on this statute, and it makes it even more troubling when it's an exemption to what Congress tried to accomplish here. And when I think it's really a classic loophole, so all kinds of things might be related to the purchase of a car, and then we get into this never land about, well, is this add-on directly related to the purchase of a car? Is this add-on involved with the purchase of a car? And we get into to differences of interpretation between different courts and this and the rest, and as to what add-ons are involved with and what add-ons are directly related to. And it's this kind of fuzzy analysis that I don't see the statute as authorizing. It's just a textual matter for me. I make no judgment on the policy arguments. I just think the text is hard to get around.
So in fairness to the district court in this case, the relatedness concept didn't arise in the district court. That came from the Department of Defense. That is squarely in the 2016 interpretive rule. And essentially it was the Department of Defense that said that related charges would be okay and would not run afoul of the exemption, but unrelated charges like cash advances or cash outs would not be appropriate within the scope of the exemption. And so I think what the district court was trying to do is, although it had some question about the applicability of the 2016 interpretive rule outside of the context of personal property, but it said, even if we apply the 2016 interpretive rule, I think that gap is fine because it is inextricably tied to the purchase of the car. And so the district court really applied the interpretation that the Department of Defense advocated.
Well, the Department of Defense was very much behind this, and I haven't seen the Department of Defense doing, and as Judge Richardson correctly points out, it's persuasive value. We're not into Chevron territory or anything, because there's no charge to an administrative tribunal of any of this. And to the degree that I'm able to understand what the position of the Department of Defense is, the government represented that it was supportive of the fact that bundle loans were not covered by this. But what we're talking about is directly intertwined and related or involved. So we're going to give rise to all of these different tests applied by all these different courts, and neither lenders nor servicemen are going to have any kind of guidance. I guess we have to go add on top of add on top of add on, and maybe we'll have a couple of good circuit conflicts on add-ons. But the road you're going, just, it is, Congress could have used the words that you wanted, but they didn't do it.
But they didn't use a sole and exclusive either. And that, I think, is the material point here.
It
is
came awfully close to it, counsel, when it said express purpose.
But there is no,
Awfully close.
there have been 2 district court cases that have considered this, and both of the district courts have rejected the notion that use of the express purpose here meant you were limited to.
Can you respond to your colleague's argument that your reading of express purpose as being sort of specified or identified renders this sort of second piece, that is the loan is offered clause, what I think of as the second element of this conditional exception, it reads it out of the statute?
So I don't think it does, because I can envision a circumstance in which you could have a loan that was made or was procured in connection with the purchase of a car, but was not for the express purpose of financing that car. Maybe it's a title loan, and maybe temporarily they were taken out at the same time, but one was for an entirely different purpose, but you pledged the title over immediately. And so I do think they exist independent of each other.
But
And
you not only, counsel, you not only have the words
Judge.
you not only have the words express purpose to deal with, you have the word finance to deal with. And the financing of the car the gap coverage doesn't need to be part of the financing of a car. In fact, it's most car purchases, it's not.
So if I could finish responding
Thank
to
you.
Judge Richardson, and then I'll come back to Judge Wilkinson's point. I think the second point that I would make about that is that Davidson's argument suffers from the same flaw. When would you ever have a loan made for the express purpose of financing the purchase of a car, but it would not be procured in connection with the purchase of the car?
And secured by the car.
And secured by the car. So their reading, negates, factor 1 and possibly factor 3 also. So back to Judge Wilkinson's point.
Excuse me, I didn't mean to interrupt either you or Judge Richardson. I thought you had completed your answer.
No, thank you. You didn't. I'll start first with the notion that a gap waiver, which is what we have in this case, is not insurance. It is a contractual arrangement between the finance company and the borrower, in which the finance company agrees to forgive any indebtedness. So it is not a contract of insurance. And so it does have to be.
You know, this gap where your colleague on the other side said that gap waivers are voided when you take the car abroad. Do you know whether that was true in this gap waiver? I just don't have the contract right
I
now.
don't know if it was, but I think there are ways around that. That is, you can abate it while, you can tell the lender, I have to take my car overseas and can I abate it? You can also get a refund. If you decide that it becomes something that is not useful to you anymore, you can terminate.
Thanks.
It also, because it is a gap waiver, it has to be made under Virginia law a part of the finance agreement, or it has to be appended to the finance agreement. Judge Wilkinson made a point during my colleague's argument about why can't the lenders just comply with the MLA? What's the big deal? Just make the disclosures. But the critical point is, if a service member wants to finance gap, or wants to finance an extended warranty, or wants to finance leather seats or new wheels or a prepaid service contract, the MLA prohibits the lender from taking a security interest in the car. So we all know what's going to happen. Those items just simply cannot be financed, or the loan can't be made, because in most cases, service members only have the car as collateral for the car loan. And so I think it's important to realize that the protection of service members was an overarching purpose of the MLA, but the purpose of the exemption was to make sure that an overly narrow reading of the exemption did not deprive service members of access to needed credit. I mean, the whole purpose of the exemption is a recognition by Congress that service members need the ability to borrow money, to buy cars, and to buy personal property.
I have a hard time understanding how this impairs a service member's choice, because as I understand it, the lender can still offer the gap coverage as long as it complies with the disclosures in the statute. And perhaps the lender is making a loan that's going to be, perhaps having the loan outside of the MLA would be under the MLA, it might be a lot cheaper.
That is not correct, Your Honor. And the reason for that is because the lender cannot take a security interest in the car.
No, that is not correct. All it is correct is that the lender cannot bundle the gap coverage or the car wash or whatever with the car loan, but the lender can still offer the gap coverage. It just can't bundle it.
It can't, because the gap waiver has to be part of the finance agreement because it includes a forgiveness of the debt. And so it is a critical function of the car loan. It's not like an insurance policy. Don't get confused by the difference between an insurance policy.
Why is it called insurance?
It's not. It's called a gap waiver. This is an agreement between the lender and the borrower that if the car is totaled or stolen, the lender forgoes collection of the rest of the loan. And so no insurance company steps in and pays the lender off. The lender
Right.
has
It's insuring against loss, which is what insurance policies do. It's insuring against the loss of a car. And that's what insurance policies do. They insure against loss.
It is insuring against the risk of loss in the sense that word
insurance.
But it is not a policy of insurance because it has to be included under Virginia law in the financing agreement. And so that prohibits a lender from doing a separate loan. It cannot loan money for the gap waiver and then make a separate loan for the purchase of the car. Or if the service member did that, that would be, a terrible idea for them because they want, as a feature of the loan, this prospect of forgiveness. And that's reflected right there on the face of the loan. I think it's also interesting to take a careful look at what the Department of Defense has said. It has not frowned on all of bundling. It just draws the line in a different place. Essentially, if you look at the 2017 guidance that was ultimately withdrawn, and withdrawn for the very concern that we've talked about this morning, which is that the inability of service members to finance these, and in some cases, very valuable add-ons would disadvantage them and discriminate against service members and make it much more difficult for them to secure lending.
But that argument you made is a policy argument. If you want to, the question is, if you want to amend the statute, that's a fine argument to make in a legislative hearing. But what we're talking about here is the language of the statute.
Well, and the district court adopted the Department of Defense interpretation of the statute. Whether it has the force and effect of law, we know it doesn't, but it can be persuasive. And I think the district court found it to be so. And what the Department of Defense did in 2017, it had these questions and answers. What would be permitted under the scope of the exemption and what would not. And I think it's very interesting. In that circumstance, the Department of Defense said extended warranties are okay. You can finance an extended warranty, but conceptually that is no different even than gap insurance. It is insurance against the cost of repairs that you have to make. It can be purchased from a third party. It can be purchased later, probably can be purchased for much less, cost. Who knows? We don't know that. And it can be added later. So all of the same factors that the Department of Defense contests with respect to gap insurance likewise exist with respect to an extended warranty, but it said that was fine. Even more problematic, I think, is the Department of Defense's position that the financing of negative equity was acceptable under the exemption. Negative equity is if you owe more money on your trading in car than it is worth, you can finance what you owe on the first car in connection with your purchase of the second car. I mean,
I'm not sure that
nothing to do with the second car you're purchasing.
Counsel-
It is clearly a credit product. I'm sorry.
I'm not sure that your idea of a warranty and gap insurance are, that they're one and the same. And you just take what the ordinary consumer does when you go into an automobile dealership. A whole lot of people buy a warranty as part of the car purchase. I think the incidence of people buying gap insurance is much less. But a warranty is pretty much of a standard feature of the purchase of any product. But gap insurance, and I don't buy your argument that it's not insurance. It's insurance, it's classic insurance. But the point is, the warranty and the gap insurance strike me as very different. And not only as a matter of what's insured, but of what the ordinary car purchaser does, which is that they purchase a warranty. But they do not, as a matter of course, purchase gap insurance. They're different.
But I don't think there's been any test articulated that turns on the frequency of purchase or how frequently consumers purchase one versus the other. Instead, the test that the Department of Defense articulated is whether or not it was related to the product that was being financed.
Well,
Sorry, go
that's
ahead.
just not the language the statute uses, related to. It just isn't.
So can I ask the follow-up question to that? Your colleagues seem to suggest that you make two arguments. One, that express purpose means identified purpose, and that you have a sort of fallback argument that even if it's required to be related, this is related in some sense of the word. Are you arguing the first one in addition to the second one? Are these alternative arguments, or are you? I just want to make sure I understand, because your colleagues seem to suggest that you were only arguing related. And I interpreted your brief to say, no, express purpose means identified purpose. But even if you go down the Department of Defense's related rabbit hole, we would meet that rabbit hole test too.
That's exactly right. That's exactly right. And in fact, I think the United States and Mr. Davidson's view diverge. And so in part, I was trying to respond to both of those.
Totally fair. Thank you.
Do either of you have any further questions?
No,
Nope.
thank you. We would ask that the court affirm.
All right, thank you very much. We appreciate your argument here. I think you have 5 minutes of rebuttal time.
Yes, Your Honor. Just want to make three.
Minute.
I apologize.
Go ahead, please.
I just want to make 3 points in response to United Auto's argument. The first is about superfluidity. So what they say is, well, this isn't superfluous because you could get another loan in the course of procuring a car. Maybe you get a vehicle title loan, but that still renders the word express superfluous, because that would just mean you could easily have the same result by just saying it has to be for the purpose of purchasing a car. If it's a title loan or if it's a payday loan, it's not for the purpose of purchasing a car. And so nevertheless, on their view, the word express is still superfluous. The other thing they say is, well, our reading renders the first phrase superfluous, that it has to be procured in the course of purchasing a car. That's not right either. What that phrase gets at is you are getting a loan from, say, a car dealership. You're going to the dealership, you're in the process of purchasing a car, and you get the loan at the same time. That's what that phrase does. What it does is excludes from the exemption the sort of shadow financing that.
Wait, would it exclude? I'm sorry.
Sure.
So if I go to the car dealership, well, assume I'm a military, all the things, but I go to a car dealership and they say, here's your financing. And I say, I don't like your financing because whatever, I'm going to call Bank of America because I have a relationship with them and I want to get my loan from them instead of from the car dealership, right? We would still say that's in the course of purchasing a car, right? Because I'm doing it as part of my same course of action. It's not from the car dealership's perspective, it's from mine. It's not limited to if I'm getting it from this dealership, is it?
I think that's right, but you can imagine another scenario, which is the kind that I think the Congress relying on a lot of study from the Defense Department was trying to prevent, which is go to a car dealership, you buy a car, or you go to, because the personal property exemption is the same text, you go to rent a center and you want to buy a couch and there's installment payments and you turn out you can't make the installment payments. So then you go to a payday lender afterwards. It's to finance the purchase, to finance the car, to finance the couch you just bought. It's not in the course of doing so. And so what that phrase gets at is this sort of shadow financing that often was targeting service members, which is a sort of after the fact kind of financing of things like payday loans and more traditional sort of loans that we think of as predatory loans. And so the middle phrase, our reading of the middle phrase is the only reading that gives that phrase, gives each of these phrases any independent meaning. On our reading, on United Auto's reading, that middle phrase just has no application. And the second point I want to make is this question of Virginia law. And I think it's useful to look at exactly what the provision they're citing says. It's on page 21 of United Auto's brief. Now that provision doesn't require anything at all. It's a definitional provision. So it doesn't say if you have gap coverage, it has to be in the loan, or even if the lender wants to issue gap coverage, it has to be in the loan. What it says is if the lender itself is selling the gap coverage, and if it does so as part of a financing agreement or in an addendum, then we're going to call that a gap waiver, and then we're going to impose some regulations. In other words, Virginia has come to the same conclusion that Congress came to in enacting the Military Lending Act, which is if you're going to bundle this coverage with a car loan, we're going to regulate it. That's exactly what the Military Lending Act says as well.
But the danger here that you're pointing to is that you use the word shadow financing and it clandestine, but the danger here that the statute tries to clear up is that the service members don't know what they're being hit with. And when when all of these different things are bundled, they don't know what the loan is for, and they don't know what exactly what add-ons and pay-ons and what interest rate they're being hit with. And one of the problems here is that all of these loans, sometimes lenders try to attach exorbitant rates of interest on these loans, and the dealings with the car purchase are sometimes complicated and involve different items and the rest. But the bottom line is these service members a lot of times do not know what they're being hit with.
Yes, Your Honor, I think that's right. And I think that's why the Navy has said in testimony to Congress before the most recent Defense Department regulations that automobile dealerships acting as loan brokers can do far more damage than even payday lenders. And they were getting at exactly this point. If you can pack anything you want, fees, ancillary products into a loan, it's very difficult for a service member to know what's there. And then the service member is risking their car, not for the car loan, which you have to put your car up as security to get, but for all of these ancillary products. And we know that Congress didn't intend for that to happen, because if these ancillary products are sold separately, we know United Auto doesn't dispute that the Military Lending Act regulates them. So we know that Congress did not think that service members should be able, or that lenders should be able to take service members' cars as collateral for things like gap coverage or insurance, things like that, because that's prohibited under the Military Lending Act. The only question here is, can you get around that by bundling things together? I think the very specific language that Congress used demonstrates that you cannot. If there are no further questions, we ask that this court reverse.
All right, I certainly do thank you. And we thank all of you and appreciate very much your arguments. And we will ask the courtroom deputy to adjourn court, and we'll take a 5-minute break and then come back and conference our cases. Thank you both. Thanks to everyone.
This honorable court stands adjourned until tomorrow morning. God save the United